Welcome back to Chapter 3 in your Workers' Compensation curriculum. Chapter 3 is Employers and Employees under Workers' Compensation. And the focus of this chapter is on distinguishing between employers and employees and those definitions under the workers' compensation systems found at the state level. Remember, in Chapter 2 we were talking about the federal level. Chapter 3 we're coming back down to the state level. We're going to talk about definitions under state statutes. This chapter explains not only who qualifies as an employee under the system, but equally as important, who does not qualify under that definition. For example, the chapter explains the differences between employee and an independent contractor. We're also going to take a look at important legal definitions of what constitutes an employer for purposes of workers' compensation benefits and how that definition can be affected by various business organizations or entities. By the end of the chapter, I want you to be able to describe the definition of employer and employee under workers' compensation rules, define statutory employer, casual employee, and describe the significance of classification as an independent contractor. You should also be able to explain the rule about workers' compensation coverage when there's more than one employer for a particular employee, and demonstrate the consequences of wrongfully denying workers' compensation coverage. Now, the big thing we're going to look at in this chapter is exactly who qualifies as an employer and employee under the workers' compensation system. Because simply put, if a person doesn't meet the qualifications of either, then the system doesn't apply. And if the system doesn't apply, the employer is not required to provide insurance, and the employee doesn't get the benefits of those workers' compensation insurance plans if they're injured on the job. At first glance, it might seem obvious who qualifies as an employer, but that classification isn't always as clear as you might suppose. For instance, we have the situation where we have multiple employers, where a general contractor and subcontractor are involved, or where a temporary agency and a hiring agency are involved. And we also have situations where we have independent contractors or casual employment, odd jobs, and so on. So we'll take a look at those so you have a clear understanding of when somebody's an employer and when somebody's an employee. Generally speaking, when we're trying to determine if someone is an employer, you're going to look to control. And the general definition is that an employer has the right to control the actions of the employee, and the employer pays the wages, then they are going to be an employer. But remember that we're dealing with state law here, and every state sets its own parameters about the definition of employer. To be absolutely sure, you're going to have to check the definition in your state. So that's what I want you to do right now. Pause this video, head out to the North Carolina Industrial Commission website, and figure out what the definition of employer is under the North Carolina system. Go ahead, I'll give you a minute. Okay, and this slide is why I wanted you to go out and find that definition for yourself, because you can see that most states do not have that minimum number of employee requirement, but North Carolina, as you've now found out, does. In North Carolina, you have to employ 3 or more people in order to be considered an employer. Back in the 70s or 80s, most states wiped out that minimum number of employee requirement, but North Carolina still has it. And keep in mind that temporary or seasonal workers can go towards satisfying that minimum number. Alright, let's look at the issues surrounding multiple employers. What happens in a situation where a person works for one company but then is loaned out to another company? You see this a lot of times with temp hire agencies. They hire people in and then they loan them or lease them out to other companies. So who's the employer in that case? The strange answer is that it could be both. But what you're going to look at again is control. It all depends on what rights the employers have. If it turns out that the new employer has the right to hire, fire, and pays compensation, then the new employer is going to be the quote-unquote employer under the definition of the statute. If not, then the original employer, that temp hire agency, is going to be the employer and thus required to pay into the workers' compensation insurance scheme. Again, we're looking to that element of control over the employee. One way that courts will make the determination as to who is the employer is by using what's called the economic reality test, which uses 4 questions to make a determination. Now, this standard examines a number of criteria, including control, payment of wages, hiring and firing, maintenance of discipline, common objective, and so on. These factors are viewed together in their entirety under what we call a totality of the circumstances test. In other words, no one factor is controlling, but they all build on each other. Now again, every state is going to have their own definition that specifies exactly who qualifies as an employer. Take, for example, this definition where any type of business entity or any person other than nonprofit or charitable organizations that has 5 or more workmen can be an employer. Again, pause here, go back to that North Carolina Industrial Commission website and check out who can be an employer or who is an employer under the definition in North Carolina, and then come back. I'll give you just a second to do that. Now that you've done that, you've probably seen that North Carolina has some very specific requirements with regards to railroads, with regard to agricultural workers, with regards to radiation, which is interesting. But again, it's a state-specific definition, and you need to find the definition for whatever state you're working in. You also noticed in the North Carolina definition that it talks about different entities, different business entities as employers, from sole proprietorships, partnerships, limited liability companies, and corporations. Now, if you haven't already taken your corporations class, you may not understand why this is important. Essentially, a sole proprietorship is one person without a separate business entity who runs a business. So there's no distinction between the business and the owner of the business. A partnership is where you get two essentially sole proprietors and put them together, and two business people form a partnership. It can be 2 or more people. Limited liability companies and corporations are separate business entities. In other words, the owners have a corporate veil between their personal assets and the business itself. They're 2 separate entities, the owners and the business. Common to all of these is that they're not employers unless they actually have employees. And very specific to sole proprietors and partnerships, if you think of a sole proprietor as a small business person who maybe cuts lawns or washes cars or something like that, they may not have employees. It may just be them. So that doesn't qualify as an employer, therefore doesn't require workers' compensation insurance. Same thing with a partnership. If you have 2 partners that come together, one partner is not the employee of the other partner, and just having a partnership in and of itself doesn't require workers' compensation insurance. In other words, they don't fall under the definition of employer. If, however, either of those 2 types of businesses, sole proprietorship or partnership, take on additional employees, they may very well fit under the definition of employer in a workers' compensation statute. Okay, the term statutory employee is very important because, as you'll see throughout this course, state governments do all that they can to make sure that no employees, no workers fall through the cracks. In other words, as many workers as possible are covered by workers' compensation statutes. And so they've developed this term or this category called statutory employer. And it's made specifically to deal with a situation where there's a question about the employer-employee relationship or the definition. And there may be cases where an employer doesn't qualify as an employer under any other definition but the workers' compensation definition. So it's a very specific definition, again, to make sure that we gather as many workers as possible into this insurance program. And I think the definition and the coverage will become a little bit more clear when we start talking about employees and we get to the subcontractor definition. But keep in mind, the whole idea behind creating this classification is to ensure that as many workers as possible are covered. Now, just as our definitions tell us who is included in the definition of an employer, they also tell us who's not included. In a lot of cases, you're going to find that charities and nonprofits are not included in the definition of an employer. Interesting, though, I think you noticed when you were reading the North Carolina Industrial Commission website's definition that you didn't see any limitations on nonprofit organizations there, did you? So we fall under that second bullet point where we do actually classify workers for charities and nonprofits as employees, or more importantly, the charities themselves as employers. Okay, so once we've determined whether or not a business entity or a person is an employer, what happens if that business entity or employer doesn't have workers' compensation insurance, or if they have it and they wrongfully deny it to their employees? Well, the simple answer is that the employer remains liable for workers' compensation coverage. In other words, if the insurance has been allowed to lapse or they just simply don't have it, they're still going to have to pay the same benefits as they would had the insurance been in place. And what's more, they're going to be subject to some fines for every day they go without a policy. Okay, One thing that will eliminate the need for workers' compensation insurance is what's called casual employment. And this is work that is provided at periodic or no fixed interval, no set time. In other words, the casual employee isn't guaranteed a job at all, never knows when the next one will come along. They have no set times to appear and no scheduled days to appear. They may just get a call from time to time to do some odd jobs. Alright, so now we understand the definition of an employer. Let's look at the definition of employee. The most common definition, the broadest definition, is regular employee. Now, this doesn't mean somebody who shows up for work every day. It just means someone who routinely works for the company, even if that's only on a seasonal basis. And the key element we're going to look at in determining employment status is the question of compensation. Unless an exception applies, then we have compensation for work. You're probably going to be an employee at that point. And those same statutes that provide us with the definition of employee also tell us who does not qualify for workers' compensation, who is not an employee. One of those situations is domestic workers. Those are people who act as maids, cooks, and housekeepers for others. Generally, they're excluded from state workers' compensation laws. And again, in North Carolina, that holds true. Domestic workers who are directly employed by a household are not included in your workers' compensation statute. Odd jobs should look a lot like casual employment to you. This is when individuals or companies hire someone to perform a single task, sweeping the driveway, cleaning the gutter, something like that. Those people do not qualify as employees. Interesting side note here, professional athletes do qualify as employees and fall under the workers' compensation laws as long as they are injured when they are playing the game or practicing or doing something that relates to their professional duties. Now we're going to get back to the whole idea of statutory employer and subcontractors, and hopefully this will all come together for you. Over the years, there have been many cases that have tested the limits of the definitions under the workers' compensation statutes, and subcontractors is certainly one of those areas. And in a typical contractor-subcontractor relationship, a GC, or a general contractor, is brought in perhaps to build a house or work on a project, and that GC hires subcontractors to carry out very specialized work. For example, the GC is going to hire somebody to do the electrical work or the HVAC work or hang drywall and so on and so forth. Now, the term statutory employer, or the concept of statutory employer, was meant for exactly this situation. In a statutory employer situation, that general contractor is going to be considered the employer for purposes of workers' compensation law. Don't get that confused with the definition of employer for other rules like IRS rules. It is only for the purposes of workers' compensation law. And if you think back to the reason for that statutory employer category, it was to make sure as many workers as possible were covered under this insurance concept. And so in a situation where a subcontractor is injured on the job building a house or so on and so forth, they're going to apply to the general contractor's workers' compensation insurance carrier to pay for their injuries. Now, contrast subcontractor with independent contractor. Very different concept, very different result. An independent contractor is a freelance agent who controls how he or she actually performs the job and has little or no direct supervision from a boss or manager. So let's go back and look at our situation where we have a general contractor building a house. Now, we know that the subcontractors would look to the general contractor's workers' compensation insurance under the definition of statutory employer. However, the relationship between the general contractor and the homeowner that hired them is different. The general contractor is independent from the homeowner. There is no employer-employee relationship between homeowner and general or independent contractor. And so if the general contractor is hired on the work site, they're not going to look to the homeowner for workers' compensation insurance. And that, in a nutshell, is the difference between an independent contractor and a subcontractor. The courts are generally going to use two questions to determine independent contractor status. If the answer to either of these questions is yes, the worker is not an independent contractor. However, if the answer to both of these questions is no, then they are. So the questions are, does the employer have the right to control how the employee actually did the job? And is the worker substantially and economically dependent on the employer? Just a few more slides here. I want to talk about some new restrictions on employers under workers' compensation. There's been some new rules regarding employers and how they provide insurance coverage. One is the opportunity to self-insure. Companies who meet minimum financial standards are permitted to be self-insurers. In other words, they don't have to go to a third-party workers' compensation carrier. They can be in-house insuring. They're going to pay those claims, workers' compensation claims, out of their own funds instead of looking to an insurance company to do it. And that is allowed in North Carolina. Proof of workers' compensation coverage has become a hot topic, and many counties or municipalities are requiring that contractors or business entities have some proof of workers' compensation insurance before they will allow them to get a business license, get a building permit, get certain certificates, fill out certain county paperwork. And it's just an enforcement mechanism to make sure that as many workers as possible are covered, and to make sure that the employers have the coverage that they need. Okay, I just want to summarize the chapter here. We've talked about the definition of employer and employee and how extremely important that is in order to figure out who is and who is not covered under the workers' compensation statutes in your state. An employer is someone who has workers. Employers must pay into the compensation fund either by being self-insurers or obtaining third-party compensation insurance. An employee is generally someone who works regularly for a company. When that employee qualifies under the workers' compensation statute, it means that he or she is entitled to file a claim through the system when injured on the job. So we've covered some important basic topics here today. If you have any questions, don't hesitate to contact me. Otherwise, I hope you have a great week, and we'll see you back here for Chapter 4.